Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Hey, here's the hypothetical that we're going to work from today. Let's go all the way back to the time of the founding of the United States. We have a tradition that if you are convicted of behavior, which is defined as a felony, it will in fact equal disarmament. Now, when we talk about this particular period of time, there is no doubt that these types of activities constituted very serious and oftentimes very violent activity. But what if over the course of time between state and federal governments, what we defined as felonies or what we defined as any type of crime in which you could be jailed for more than a year actually continued to grow and grow and grow? In fact, it grows to the point where it includes all sorts of activity that is nowhere close to being violent. Now, let's say you are a person that's been disarmed, not for activity here, but for activity here. And you want to challenge that law and believe that you're entitled to have your Second Amendment rights back. Well, one would think that you could file an as-applied challenge and say, hey, listen, when you take a look at the facts of what I was convicted of, I don't really fall into that dangerous category, and therefore I should not be permanently disarmed. But then, what if I told you that in some courts, including the Ninth Circuit, you can never, ever, ever make that challenge no matter what? Because if you got convicted of a felony, no matter what it was, no matter what it involved, that's the end of the inquiry. That's the hypothetical, except here's the problem, America. That's not a hypothetical. That's actually how it works in parts of the country. So we're going to talk about a case that's sitting this close to being accepted by the United States Supreme Court that is immensely huge for that reason. So today, let's spend a few minutes and let's talk about how they've slowly disarmed America and the case to stop it. Okay, America, we are talking about a case that is not only sitting before the United States Supreme Court on petition, actually has a conference scheduled for November 21st. The case is Duarte versus United States of America. It is a challenge to 18 United States Code Section 922 G1, what we call the felons with firearm rule, but it is not really a challenge to the overall constitutionality of it as much as it is a challenge to what the Ninth Circuit and other circuits have ruled, which is that you never, ever, ever get to make an as-applied challenge to this statute. What really makes the amicus brief, however, that we're going to talk about today is that it is authored by a whole slew of public defenders. As a matter of fact, I'm going to put all of their names up. Kudos to all of you. This is an excellent brief. I'm only going to get through part of it. If I actually did a video about all the good arguments they made here, it'd be about a 25-minute video. Now, listen, if you really want to understand what impact a legislative scheme has on the criminal justice system, you can get anecdotal stories from people such as me, or you can talk to the public defenders, because the public defenders live their entire life in the trenches. They represent more people than any other group combined, and they will always be able to tell you the impact, good, bad, or indifferent, on the criminal justice system. They come at it, especially as it relates to the Ninth Circuit's ruling, which is on appeal here, this way. The Ninth Circuit purported to find that there is no limit to the legislature's power to categorically disarm groups of people. The court has since used this decision to effectively eliminate as-applied challenges to not just felon in possession laws, but all class-based criminal disarmament laws. So think about it. If we're in a situation where state and federal legislatures continue to expand this, and then we have no way of ever challenging should it really apply to me, think about how many people can be disarmed. And for that reason, the public defenders, through their amicus brief, raise the following. Amici submit the following brief to illustrate the magnitude of the Section 922 G1 problem and the need for an administrable as-applied approach. Now, at the very beginning of this video, we talked about this phenomena where both state and federal legislatures have just grown what's defined as a felony behavior, or grown what's defined as jailable by up to or more than a year. And that has led to a situation where we have disarmed millions and millions of Americans, perhaps for the wrong reason. As the amicus party wisely points out, Section 922 G1 and its impact are uniquely modern creations. In the late 1940s, fewer than 2 million Americans had felony convictions. Today, between 20 and 24 million Americans are felons. That growth is not attributed to enforcement alone, but also to the growing number of felonies Americans can be convicted of. And between 2000 and 2007, the federal government alone added, on average, 57 felonies per year to the United States Code. Now, I know every time I do a video about this particular topic, a lot of you claim, like, this doesn't apply to me at all. I'm not a felon. Why should it matter? Well, it applies to somebody that you probably know or probably somebody that you care greatly about. But more importantly, if you have any sense of fundamental fairness, unless individuals are allowed to make as-applied challenges, what we're going to end up with is more examples like this. Christopher Collins, who when he was 20 years old, 17 years ago, was convicted of embezzlement for taking money from the till of a cash register. Found in possession of a firearm, he now is facing up to 15 years in a federal prison. Francisco Hilt, who was convicted by a no contest plea in 1999 with possession of marijuana with the intent to distribute in California, now serving a 165-month sentence for a conviction under 922G1. Trevor Young, who in 2017 was convicted of shoplifting $253.46 worth of merchandise. Found in possession of a firearm, convicted under Section 922G1, now serving an 18-month sentence. Justin Meyer, who back in 2012, when he was 21 years old, was convicted of stealing a phone worth about $300. Now found in possession of a firearm and charged under Section 922G1, is facing up to 15 years in a federal prison. Which leads to this phenomenon that the amicus party wisely illustrate, which is, among the thousands of persons singled out for prosecution under 18 United States Code Section 922G1 each year, nearly half have prior convictions that did not involve misuse of firearms or violence against others. Now, and perhaps what is my favorite part of a brief that I'm a big fan of, the public defenders here point out that, hey, listen, didn't you guys have a Supreme Court case just recently that did talk about another section of 922G? Yeah, that's called United States v. Rahimi. It was 18 United States Code Section 922G8. Didn't you guys do an as-applied analysis there? Yeah, you actually did. Which gets us now to our first ever edition of
the Reverse Rahimi.
Or as they put it, this does not mean that the law should remain trapped in amber, but it does underscore the futility of using historical punishments for felony offenses, none of which involve the specific penalty of disarmament, as a lens through which to evaluate the constitutionality of Section 922G1. Because the point, America, is this, is that if there really is no as-applied challenges, if the inquiry is simply going to be as simple as did you get convicted of a felony or did you get convicted of an offense in which you could have been punished by more than a year in jail, then what stops any state or the federal government from taking what already looks like this and making it look like this or this? And that, my friends, is how they have disarmed millions of Americans, how they will continue to do more, and while this is the case that is meant to stop it. Okay, the case once again is Duarte versus the United States. We're going to link up the amicus brief down below so you can geek out on it for yourself. Kudos to all of these public defenders for weighing in on this fantastic brief. Job well done. Listen, if you got any questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now, but if you don't, that's okay. That information is down there in the description box. If you got an idea for a video we should do around here, you click on that link right there and you tell us all about it. If you want to subscribe to the monthly newsletter, the information on how to do that is down there in the description box. And then finally, and most importantly, let's everyone remember that part of being a lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe. They're saying, you know, what happens is these people get involved in these situations and then they're just denied coverage.
Yeah.
And I think that the model of what some of these companies run, as far as they run like insurance companies, actually leads to that result a little bit. But, you know, that's a fair criticism. People are going to invest money and you're going to be there when it hits the fan, and then it hits the fan and you're not there anymore. What can Right to Bear say that's going to make them different?
Well, yeah, I think that's a great point. You know, I come from the insurance industry, so I know it well. I know that insurance contracts are written by attorneys for the benefit of the insurance company, not the insured.
That's right.
So what we did at Right to Bear is, you know, we're first off, we're gun people that are in the business of supporting gun people. When we started the company, we knew of the numerous other players that had this market pretty captivated at the moment. And after reading their contracts of everybody, we determined that, hey, we can structure an arrangement that gives people and really the citizens of our country somebody that's going to be there when they need us most. That was what we prided ourselves on. And I know that sounds like a marketing piece, but it's the truth. That's why we started the business, right?
You're not truly prepared unless you have Right to Bear back you. You will always get an attorney answered hotline, so you will always have a confidential phone call. There are no cap limits for either civil or criminal defense. This covers all forms of self-defense. So from a fist to a firearm, from a fat lip to a dead body, you are covered, and you will have some of the nation's most passionate 2A attorneys in your corner fighting for you. And right now, if you visit my friends at protectwithbear.com and you use the promo code WGL, you will receive 10% off. Listen, you need to protect yourself so that you can protect them. Visit my good friends at protectwithbear.com.